Welcome to this edition of the Mortgage Terminator. In the past couple days, it's really amazing how quickly news travels. I've gotten 5 or 6 emails from clients and managers about the so-called Mortgage Terminator, which is the name given to a win by a South Florida law firm in a case that they held. Well, I've had the chance to look at the pleadings in that case and look behind it, and basically it's quite a unique set of circumstances. Let's go through it, because there's a difference between getting a good result under unusual circumstances and then coining a very interesting phrase and getting great press releases, and also doing the hard work in the trenches that it takes to protect client interests. What this other law firm did was foreclosed, took title to a unit, and then sued the mortgage holder. And the cause of action isn't clear, but the docket indicates that there was a default entered and then a final judgment on the default. So the merits of the case were never brought before the court, and it's probably what's called a quiet title action, which is where a party who has title to property brings a lawsuit to try and have a court declare that whatever encumbrances on the property no longer apply. Now, that's sheer guesswork on my part, but it can only happen when the association goes all the way through foreclosure, takes title, and then has the lawyer do some analysis as to whether the holder of the mortgage has either assigned the mortgage, sold the mortgage, or whether there's any interest left in the original mortgage, or the entity purporting to hold the mortgage. That is an option available to any client who obtains title to property in a foreclosure. But the first step is that the client has to be willing to foreclose and go all the way on the litigation on the property. The second is it takes some analysis to determine whether it's appropriate to bring a lawsuit against a mortgage holder, because you may or may not win on the merits. This appears to have been a procedural victory. The third is that there's a possibility that on the merits they could lose. As those of you who have watched my other videos know, that in the foreclosure process, it's improper to name a first mortgage in your own foreclosure. We call your action the race to the courthouse steps. You try and get title to the property. Another angle that we do that I don't know that any other law firm does is that we actually attack bad faith mortgage foreclosures, and you can watch another video on that on YouTube that I've done, and we have about 300 of those cases. Those cases result in the mortgage foreclosure being dismissed without leave to amend, and that is always good for the association. It never hurts, and it also punishes both the plaintiff and their law firm, because the court awards attorney fees against them. So that's something that we recommend. What's the bottom line? Who knows whether this catchy phrase methodology will suit any particular association under any particular set of circumstances. It's definitely not a cure-all or one-size-fits-all. It's a mess out there. It's not getting better. We're still getting 30 foreclosures a day in. But what every association needs to remember to do is lien or demand, lien, and foreclose, and deal with the consequences, because there are 3 constituencies out there that you're dealing with. The people who pay, who wonder why they're paying and are not happy that so many people aren't paying. The people who are thinking about not paying, and they need to know that if they don't pay, the association will prosecute a foreclosure until, if necessary, they or their tenants get thrown in the street. Although we don't tend to throw tenants into the street, we'd rather recommend that they stay in the unit and pay rent to the association. And the third are the deadbeats out there, the ones not paying, and the ones who need to know that there are consequences. I've called it moral hazard in other videos. There's consequences for failure to pay. So if you stick to a zero tolerance policy and you go after people and you continue and move forward and foreclose and do what's necessary, and under circumstances where it's appropriate, get a court order allowing you to collect rent, as opposed to what I believe is an unconstitutional new procedure allowed by the legislature where you just demand rent from the tenants, you'll go far. But under no circumstances do I believe that this so-called mortgage terminator is a cure-all for what ails you. Anyway, until next time, where am I? Go Rays. When I recorded this, we're down 0-2 in the playoffs, but who knows? I'm a Cubs fan, so hope springs eternal. See you next time.